So when Mr. Irian described what he saw as the values of this litigation, one of the things I noted he talked about was the importance of the real people whose environment was damaged, whatever the legal judgments about that damage. And he spoke about the litigation as having the potential to provide voice to those people. So I think there's probably no one more appropriate to speak about this issue than Professor Kimerling. Professor Kimerling is a professor at the City University of New York and a lawyer and an experienced environmental litigator. And of everybody in the room, I think she is the one about whom I think it's correct to say has the longest history with this case and with the events that underlay this case. She wrote the book Amazon Crude, which the New York Times is said to have called the Silent Spring of Ecuador. And many people believe that it was that book which gave rise to the litigation. So I want to welcome Professor Kimerling.
Thank you. Thank you very much. And thank you. I want to thank the organizers for bringing us all together and inviting me. And so I'd like to start by offering some comments on the forum nonconveniens, and then talk about one of the affected indigenous groups, the Waorani. And I should disclose that I've been retained by a group of Waorani representatives to protect their interests in the litigation. And I guess I don't have to add that I've worked in the affected region since 1989, and because that's already been mentioned. So, forum nonconveniens, as I guess everyone here probably knows, is a doctrine that, but just in case someone doesn't, it's a doctrine that allows a court to dismiss a case that could be brought in a different court for the interests, for the convenience of the parties or in the interest of justice. And so when a federal court applies a doctrine, it first determines whether there's an alternative forum and then balances public and private interest factors to determine which forum is more convenient. Now, I've written a lot about the decision to dismiss the Aguinda case in New York, so in the interest of time, I'll cut to the chase. The application of the forum nonconvenience doctrine to dismiss Aguinda was colored by a series of detailed but questionable factual assumptions. Some of the facts used by the court were uncontested. For example, there were no allegations of injury here in the United States. But other facts were in dispute, and one key area related to control of the operations. And while not determinative itself of the legal issues, the factual issue of where decisions were made about the technology and practices that caused the pollution and who made them was a material element of the decision to dismiss. And the proposition that was advocated by Texaco and accepted by the court without live testimony that Ecuadorians controlled the relevant decisions, that employees in the U.S. had virtually no role in designing or directing the operations, and that environmental practices were heavily regulated by Ecuador is a recurring theme in the analysis of private and public interest factors. The court also distinguished Texaco from Texaco Petroleum, the subsidiary that operated in Ecuador in a consortium with the National Oil Company. And that distinction and the portrait of the subsidiary as basically an Ecuadorian company that had nothing, that was really far removed from the parent, is dramatically different from the image of Texaco in Ecuador. And the impression there that the state had contracted with the U.S. company, Texaco. And it's also at odds with the portrait that was cultivated by Texaco before it was sued, of a multinational industry leader that transferred world-class technology to Ecuador. Ecuador relied on Texaco as the operator of the first commercial fields to design, procure, and operate the infrastructure that turned Ecuador into an oil exporter. In its contract with the state, Texaco agreed to train Ecuadorian workers and turn over the operations to the state oil company in 1990. As for environmental law, there were boilerplate directives in the law, but they weren't implemented, and so in that vacuum, Texaco set its own standards, and there was virtually no environmental protection. Workers who were trained by Texaco were so unaware of the hazards of crude oil that they put it on their heads to prevent balding. And they would either sit in the sun or cover their head with a plastic cap overnight, and then to remove the crude, they washed the hair with diesel. Texaco's international prestige and control of field operations gave it enormous power in the oil patch. And this power was compounded by systemic shortcomings in the rule of law and a culture of impunity. And that power, I think, is best illustrated in a remark by a worker who gave me a ride when I was hitchhiking many years ago. He drove a truck that dumped oil on roads for dust control and maintenance. And I asked him if he had any concerns about that, and he said, no, because I went to a training session, and there was a gringo from Texaco who told us that in the U.S. they put oil on all of the roads, and people there are very smart, and they've learned that it nourishes the brain and retards aging. I asked him if he believed that, and he thought for a minute, and then he said, it doesn't matter what I think. Here, Texaco manda. Texaco gives the orders. Now, I've also written a lot about the environmental impacts of the operation, so for now, I'll just say that pollution and other impacts have made large areas of ancestral Guarani lands uninhabitable to them. And of course, other areas are affected as well. And the damages are so serious that other companies have gone to great lengths to try to distinguish their operations from Texaco. We're not like Texaco. We use international standards has become, and best practice to protect the environment has become a common refrain in the oil patch and in the media in Ecuador. The basic determination by the Aguinda Court that case, and I quote, has nothing to do with the United States, is remarkable when you consider the reality of oil development here. And I think it's an important point, not just for forum nonconvenience, but in light of the discussion we've just had about whether there is some obligation in this country to try to help set things right, or some public interest in this country, as opposed to just, leaving Ecuadorians on their own with Texaco and their government. And I think that this also sends a troubling message that laws and institutions in the U.S. create and protect corporations, but decline to act when they harm people abroad. And I think the subsequent developments in the case raise additional concerns about the forum nonconvenience doctrine. After arguing for 9 years that the case should be litigated in Ecuador, Chevron's now back in New York, as we all know, saying that Ecuador's courts do not provide an adequate forum to administer justice. And I understand that there are very serious allegations about the conduct of the litigation, and I want to be clear that the Guarani did not participate directly in the Lago Argrio litigation or in any of the alleged misconduct. I should also say that was not involved in bringing the Aguinda case either in New York or Ecuador, have not been part of the plaintiff's litigation team. And the Guarani have not been a part of that either. But they now have an interest in that judgment because it's based in significant part on injuries to them. And so if Chevron's collateral attacks on the judgment succeed, what happens to the claims of the Guarani and other victims who have clean hands, and to Chevron's obligations to them? These are important questions that seem to be eclipsed by the complexity of the litigation. The doctrine of forum nonconvenience is meant to serve the interests of justice and the convenience of the parties, but I think this case teaches us that in transnational litigation it's subject to abuse, and it can be used as a litigation tactic to avoid hearing cases by foreign plaintiffs. The standard to establish that an alternative forum exists is really not exacting. So there's no serious inquiry into the adequacy of the alternative forum. And the public and private interest factors are malleable. So more often than not, it's really not unreasonable to expect that no two judges would apply them the same way. And at the end of the day, defendants may not be held to what comes out of their chosen forum. And the final judgment may come from legal and political systems that have no contacts with the parties or the injuries. In this case, Argentina, Brazil, and Canada, instead of the alternative forum or the United States. So the doctrine, we can see in this case that the doctrine can give defendants in international human rights cases and a powerful tool, and leaves plaintiffs with enormous uncertainty. Now, I guess we can come back to this, but I'd like to talk now about the Guarani. The Guarani aren't the only indigenous tribe who've been harmed by Chevron's operations, but they've been especially hard hit because the family groups who lived in the areas where Texaco operated had no contact with the outside world when the company and what they call the civilization arrived. The Guarani have lived in the Amazon since before written history. Their ancestral territory includes lands where some of the infrastructure that Texaco built is located, and lands that were colonized by settlers from other areas who followed the roads that Texaco built into Guarani lands after the Guarani had been displaced. And I should add here that Maria Guinda lives in that area. She lives on the Texaco Road in an area that's ancestral Guarani territory. Texaco first struck oil in 1967 near Guarani lands. And at the time, Ecuador's institutions had very little influence in the Amazon. And as I mentioned, the Guarani who lived in the areas where Texaco wanted to work were free and sovereign, living in voluntary isolation in the forest. But the discovery of black gold made the national integration of the Amazon and conquest of and pacification of the Guarani a national policy imperative. It also provided infrastructure to penetrate remote areas and monies to support the military and bureaucracy. Government policies in the 1970s and 80s aggressively promoted colonization of the Amazon, and Ecuador's law incorporated the doctrine of terra nullius, a racist doctrine that was used by European colonial powers in the Age of Discovery to provide a legal justification for ignoring the rights of indigenous peoples in lands they claimed around the world. The doctrine is confused and confusing, but it's had a long-term effect on the way that Ecuador and Chevron have defined their relationship with the Guarani. And essentially, it's a legal fiction that treats lands that were acquired by European powers as unoccupied despite the presence of indigenous peoples, and denies property rights and political rights to native peoples. So this remarkable claim that the Amazon was tierra baldias, empty wastelands which belong to the state because they have no other owner, despite the presence of indigenous peoples, was the law in Ecuador when the oil boom began, and was used by the state to assert a supreme overriding title to Guarani lands and resources, and the right to subjugate and govern the Guarani. As Texaco expanded its operations into Guarani lands, warriors tried to drive off the invaders with hardwood spears. In response, Texaco, Ecuador, and missionaries from the Summer Institute of Linguistics collaborated to pacify them and end their way of life. Using aircraft supplied by Texaco, missionaries made first contact and pressured and tricked more than 200 Guarani into moving to a distant settlement. Other Guarani moved deeper into the forest to get away, and at least one group still lives in voluntary isolation. The Guarani who went with the missionaries were told that Guarani culture is sinful and savage and pressured to change. Many elders recall that time as a period of great suffering when epidemics of new diseases hurt and sickened and killed many people, and when large areas of the rainforest that had been their home were first invaded and degraded by outsiders. The complaint in the Lago Argrio case asserts claims on behalf of the Guarani and other so-called afectados, local residents who've been harmed by the operations. The afectados include 4 indigenous tribes, some members of a 5th tribe, and settlers. But the Guarani were not consulted, there are no Guarani plaintiffs, and no relief was requested directly for the victims. The judgment by the court gives control over the monies for remedial measures and punitive damages to a non-governmental organization, Amazon Defense Front. It directs the plaintiffs to set up trust funds to administer the monies and provides that the sole beneficiary of those funds and board of directors shall be Amazon Defense Front or whoever it selects. Amazon Defense Front was founded in 1994 by a group of settlers in Lago Argrio who heard about the lawsuit in New York on the radio and decided to establish a local institution to administer monies from the case. It has developed close ties with the plaintiffs' lawyers, but it's controlled by settlers and is not regarded by the affected indigenous peoples as their legitimate representative. So now, as you've heard, after more than 19 years of litigation, there's a judgment, but the viability of that judgment is in question. There's litigation in 6 countries on 3 continents with no end in sight. And there's a lot of uncertainty about how decisions by these different legal regimes will intersect, and no single controlling authority to adjudicate those potential disputes. But even if the Lago Argrio judgment is upheld on appeal, and the plaintiff's lawyers succeed in collecting it or part of it, or even if the parties decide to settle instead of litigating around the world, the impact of Aguinda on the Guarani and other afectados will still be uncertain. And for now, sadly, this new chapter in the litigation seems to be shifting the focus of the legal and political contest from allegations about Texaco's misconduct to allegations of misconduct by the lawyers and activists who manage the Lago case, and from concern about the rights of the affected communities to the rights of Chevron. Chevron is using the alleged misconduct not only to prolong the litigation, but also to try to taint the credibility of the victims' claims and to jeopardize their rights to a remedy. And all of this has eclipsed the situation on the ground, where environmental conditions continue to deteriorate, people's rights are still being violated, and no one is accepting responsibility. So as we begin this symposium, I think it's important to remember that the issues we're talking about here are very interesting and important, but at the end of the day, this case is supposed to be about justice for the Guarani and other affected groups. The representatives of the Lago plaintiffs often say in their narrative about the case that the affected indigenous peoples were decimated by Texaco. But the Guarani want people to know that they're still there. They've suffered serious injuries, and in the language of human rights law and torts law, they're victims. But they're also survivors. In accounts of the litigation, the people whose rights are being defended often appear as backdrops to a distant drama in which the key protagonists are outsiders. So it might surprise a lot of people who've been following the litigation to hear that many Guarani are taking a proactive approach to the need to remedy problems and threats that began with Texaco and continue to this day. They understand that for the Guarani people to survive, they have to protect what remains of their ancestral territory, and they're engaged in activities to do that. Now, for the Guarani, a healthy environment is about much more than cleaning up pollution and protecting natural resources. It is also intimately related to the survival of the tribe and Guarani culture and identity. Ome is the Guarani word for territory. For the Guarani who still live in the forest, Ome is a giving environment and a space where they can exercise genuine political self-determination, maintain their culture and identity, and live as Guarani without outsiders spoiling the forest or trying to dominate the people and tell them how to live. So when it comes to remedies, cases like this pose complex but not necessarily insurmountable challenges. That said, it remains to be seen whether the victory in Ecuador's courts or a possible settlement through the plaintiff's lawyers or the government of Ecuador will obtain effective remedies for the Guarani and other affected groups, or simply empower and enrich a new layer of elites and perpetuate the injustices and the injuries. The big question is, how can we translate these grand ideas and complex litigation into meaningful remedies for the Waorani and other affected groups? The decision to allow Amazon Defense Front to control the monies awarded by the Lago Argrio court reflects and reinforces the failure of the Aguinda litigation elites to allow meaningful participation by the affected indigenous communities in decision-making processes. The Waorani and other indigenous peoples who've suffered most from Chevron's operations risk becoming symbols of justice without getting justice or adequate remedies. So the Waorani are also responding to those challenges. And in November, a group of 42 Waorani representatives filed a motion to intervene in the lawsuit by Chevron in New York. The purpose of the motion was to help defend the validity of the Lago Argrio judgment, but not any alleged misconduct by Amazon Defense Front and the lawyers, and also to protect interests of the Waorani in the judgment. And I'm co-counsel for that group, and our papers allege that the judgment is based in significant part on injuries suffered by the Waorani and that it recognizes their right to benefit from the judgment. We also asserted cross-claims against the Donziger and Amazon Defense Front, seeking a declaration that the Waorani are entitled to recover their share of the judgment, an accounting, and the imposition of a constructive trust. And we also included claims for breach of fiduciary duties and unjust enrichment. The cross-complaint alleged that the defendants have a conflict of interest with the Waorani and that the decision to award control over the judgment monies to Amazon Defense Front was made without consulting the Waorani. All of the parties opposed the motion to intervene, and in January, the court denied it as untimely, and also because the court ruled that the existing parties will protect the Waorani's interests in that case. Insofar as the Waorani seek to protect the Lago judgment, the court said that their objectives are aligned with the Lago Argrio plaintiffs, who are also defendants in that case, and that their defense of the judgment will protect any interest the Waorani may have. As far as the cross-claims, the court acknowledged that Donziger and the Lago Argrio plaintiffs will not represent those interests or objectives, but it ruled that Chevron could be relied on to do so, because its challenge to the Lago judgment includes allegations that the plaintiffs' lawyers have schemed to ensure that monies from the case will first go to an offshore trust to pay the lawyers and investors, and that the residue will then go to the Ecuadorian trust, which they control through Amazon Defense Front. The court also said that the Waorani could pursue their cross-claims in separate lawsuits in New York State and other courts, and that their presence in the Chevron action would delay and complicate an already complicated lawsuit that is well along the path to trial in fall of this year. So that's where things stand now, and I think there are a couple of lessons here, lessons not learned. I say lessons not learned because they reflect long-standing patterns of inequity and exclusion. First, the dispute with Amazon Defense Front is unfortunate. But it's not entirely surprising because it's not uncommon for conflicts of interest to rise between indigenous peoples and external non-governmental organizations, NGOs. The NGOs claim to speak for and to represent indigenous peoples. But when local communities and community members try to speak for themselves and participate directly in processes that affect their rights and interests, all too often, the NGOs and their associates perceive a threat to their own interests and marginalize the grassroots actors. This is a widely recognized pattern that I believe has repeated itself in this case. Indigenous communities around the world are working to rectify this recurring challenge, and these same fundamental concerns and aspirations are a major factor that's driving the decision by my clients to seek to participate in the litigation. A lesson I think we need to learn is that inclusion and participation do not happen because an outsider claims to represent a group like the Waorani, or even chooses a member or a few members of the group to represent them. It needs to be experienced as inclusive and respectful by the members of the group. And that means allowing them to choose their own representatives and to be engaged in a meaningful way if that's what they want. Another long-standing pattern that's reflected and reinforced in this case is the failure to recognize the cultural clash between our legal system and Waorani culture and law. The Waorani had been subjected to an external legal regime without their consent and excluded from decision-making that affects them. And we can see the culture clash in the decision to deny the Warani's motion to intervene because it holds them to our standards of timeliness, chides them for not jumping into the case fast enough, complains that participation by the Warani will delay and complicate the proceedings, and contends that excluding the Warani will not be prejudicial because any concerns or legal interests they may have will be protected by other parties. Of course, there's a certain logic to this in our legal culture, but there's another dimension that we need to think about as well. The perspective and experience of the Warani with our law and the concerns and aspirations that led them to decide to try to engage with our legal system in order to protect their interests in the litigation. And this began when a BBC film crew visited one of the communities a couple of days after the Lago judgment was issued to do a story on another topic about conservation and oil development in Yasuni National Park. I was visiting at the time, and one of the producers asked what we thought about the judgment. The news sparked a conversation in the community, and the Warani asked me to investigate. One of the principles that guides my work in the Amazon is to help grassroots community members educate and empower themselves so that they can bring their voices to the table as direct participants in processes that affect their rights and interests. So I agreed to find more information, and that led to a process of reflection and decision-making in that community and neighboring communities, which in turn led to a decision to work together to better understand and participate in the litigation. Initially, they tried to have a dialogue with Amazon Defense Front, but the organization refused to give them information on the basis of its purported representation of the Warani and its plans to use monies from the judgment to remedy their injuries. It even refused to disclose whether rumors that it's made a deal with the government of Ecuador to administer monies from the litigation are true or not. So now the Warani representatives want to use our legal system, but they still see it as our law, not theirs. Remember that before Texaco arrived, their family groups were free and sovereign. Their rainforest territory gave them life and their way of life, and they lived in accordance with their own culture and law. The Warani referred to non-Warani as Kowode, which means strangers in their language. So after Chevron and Ecuador decided to extract oil from Warani lands, the Kowode used their law to impose, override, and violate Warani law. The Kowode law asserted an overriding right to own and colonize Warani territory, to extract oil and damage the forest, and to dominate and govern the people. Of course, we all know some version of this history, but most people think it ended hundreds of years ago. But for the Warani, this history of conquest and domination began just a few decades ago. And with it came a process of loss of territory and natural resources, rapid change, and external pressures that now threaten their survival as a people. The Warani I represent understand this, but they're determined to survive and, as they say, leave their own history and pass on their culture and territory to their grandchildren. And although they're beginning to see tools in our legal system that can help them coexist in peace with the Kowode, they also feel endangered by our law because we have not learned how to take into account Warani culture and the very real differences between their culture and ours. And we have not learned how to remedy the long-standing injustices and roots of human rights violations against indigenous peoples. From their point of view, our law is a powerful and mysterious process that attacks their law and erodes their rights and seeks to dominate and impose. So the lesson I think we need to learn is how to better respond when the Warani and other indigenous peoples seek to engage in new and constructive ways with our legal and political processes, whether it's to remedy violations of their rights or address the root cause of those violations. This is important not only for the Warani, but also for us, because the way our legal system is perceived by other people matters, by the people who are affected by it. Lack of meaningful participation and failures in the administration of justice hurt us because they erode the legitimacy of our legal system in the eyes and experience of people who are affected by it. And they beg the question, what kind of society are we? If we simply resolve disputes by power, why do we need law? Law should be about justice. I know this sounds idealistic, but I'm going to say it anyway. Law should be about justice and the administration of justice and effective remedies, even in the most complex litigation. So I'd like to end by posing what I think is the most obvious and important question in this case. What are the victims left with, the true victims left with, by way of remedies, since this judgment is in question through no fault of their own? Thank you.
There you are. So I promised the first question.
I want to thank Nick and Matt and Anuja for putting together this incredible conference. I'm very gratified that Judith got the last formal word of the morning. It's an inspiration to see someone with clean hands who can speak for the real victims, who are not the only victims. And I call on Chevron to back up its language of social responsibility and to devote any recovery in significant part to the Irani and to other victims who suffer from deprivations of social and economic rights. As I hope that remark shows, I come from a perspective of advocating corporate accountability and writing much of my career from the perspective of human rights plaintiffs. I don't mean plaintiffs' lawyers, but plaintiffs. But I took Ted's bet. I did wade in and looked at scientific evidence on both sides. I looked at all of the procedural evidence and the substantive evidence on both sides. And he is absolutely right that there is only one side to this case. And I am appalled at the inability of commentators in all arenas, in journalism, in the academy, in human rights advocacy, to actually the unwillingness to accept that this might be so, and to actually immerse themselves in the facts. A few.
There questions?
Yeah. Oh, I'm sorry.
You're going to have.
I mean, Nick sort of said, "Oh, maybe I could put you on the list." But I'm going to end with some questions for Ted. Can I? Do you mind? Do you want to come in with?
It's fine with me.
Well, I'd like to.
Thank you for your comment.
Let's start with questions for Judith, and then we should have at least 15 minutes to make more general questions. But
okay,
I am going to say, I think at this point, let's not make statements. Maybe, Rick, you have a question.
Which is a very general question that sort of ties in with your interest in Forum Non, but is broader. My distant and uninformed reaction to what you said, this is Rick Marcus, was that the Warani have suffered most because of what Ecuadorian government and law have done to them, and that they are seeking now, and maybe in other ways, but seeking now in connection with this litigation to have the U.S. courts save them from some of that history. That seems a curious kind of argument to make, either about the adequacy of the Ecuadorian legal system, or the adequacy of Ecuadorian law, or the proper role for U.S. courts in dealing with these legal problems. It sounds like it's a really totally different discussion than I was focused on, and I'm wondering how you think the U.S. courts are supposed to determine what law ought to apply to these folks.
Yeah, I think that's an important question, and let me clarify that the Warani are under no illusion that U.S. courts are going to resolve all of their problems. And they're under no illusion that all of their problems are because of this case. So the Warani are also working, I've been working with this, an alliance of Warani communities, and they're trying to get the government of Ecuador to recognize their land rights and respect also their self-determination rights. And that's completely separate, you know, processes where they've come together, they're organizing or trying to engage also with the Ecuadorian government in new ways and to change their relationship with the Ecuadorian government and their law. So they are engaged in doing that. I wish I could tell you that, you know, that they're having success or not. I mean, the current government of Ecuador has made a lot of statements recognizing the historical wrongs that the state of Ecuador has committed vis-a-vis the indigenous peoples and its interest in changing that history. And so the Warani communities that I work with have tried to pick up on that and actually engage with the state to do that with respect to their rights and self-determination rights. So that is a separate issue. But nonetheless, there's another issue. That the Warani suffered major, serious injuries because of Texaco's operations. And I understand that the government of Ecuador shared some responsibility for those wrongs, but two wrongs don't make a right. And it doesn't, you know, it does, so there's no question that the injuries that the Warani have also suffered very real injuries because of Chevron's operations. Now, I didn't go into a long lecture showing the waste pits. I could tell you which oil fields and which facilities that Texaco built are in Warani ancestral lands and which have made those lands uninhabitable to the Warani. So there, I mean, you know, I could go through. I didn't think we were supposed to litigate, but I could certainly substantiate facts of the, you know, related to the injury that the Warani have suffered. They have lost a huge amount of their territory because of Chevron's operations. I mean, they, you know, a lot of their former lands are no longer inhabitable for them to live as Warani because of the environmental impacts from those operations. And in addition, there's an enormous social impact that really was carried out by Texaco and the government and the missionaries in furtherance of Chevron or Texaco or Chevron's operations. And that was to basically pacify the Warani and remove them from the areas where Texaco wanted to operate. And of course, that's something that has had enormous consequences. So, you know, when we think about remedies, there are many things that could be done. If that judgment is upheld, you know, if the judgment survives, if some remedies survive and claims, and there are some remedies, they're enormous. There's a lot that could be done to ameliorate the injuries, not to put things the way they were before, but to ameliorate the injuries and help address many of the injuries that the Warani have suffered. But in order for these remedies or the judgment to do that, they need to be part of the decision-making processes and how that will happen. But you know, they're under no illusion that a U.S. court is going to solve all their problems. It's not that simple.
So Judith, at the beginning of your presentation, you talked critically about the court's decision to dismiss on FNC. So I want to ask you a version of the question I asked Ted. Do you think the Waranis would have fared any better had the case remained in the New York Southern District? Is this issue of the issues of voice and participation by the actual victims a problem that, in your view, U.S. courts address well, or would have addressed any better?
Well, it's hard to speculate, but I do think that one important difference is that U.S. courts have more experience with complex litigation, and in the context of class action litigation, there are procedural mechanisms that are designed to protect the interests of absent class members. I think it would have been difficult to certify a single class in this case, because you had colonists and indigenous peoples. I mean, you had, who clearly have overlapping, common issues of fact and law, but also have some conflicts of interest. And I think that those conflicts are part of the problem in the way that the judgment structures the remedy. But I think that there are mechanisms in class action law that are intended to protect absent class members, and that those are extremely important. Would they have functioned properly? Okay. Perhaps not. I mean, that's a much harder question, and it would depend on the judge. It would depend on the quality of the advocacy, but at least there's some avenues there that provide a way to begin to address those questions. But, I think the issues with timeliness, as we saw in the motion to intervene, may have been problematic, but perhaps not. Ultimately, it would have depended on the judge and the
Other questions specifically for Professor Kimerling? Yeah.
So thank you again for coming here, Professor Kimerling. And I wanted to go back to the point you made about...
identify yourself?
Oh, sorry. My name's Joel. I'm a student here at Stanford. And so you were talking about lessons learned and maybe lessons not learned. And one context where maybe some of this might replay is we're starting to see, certainly nothing new, but an upswing in oil and gas production in Native American lands in the United States and Canada. And I was wondering, as more and more domestic environmental NGOs get involved in that, what they can learn from experiences in Ecuador and elsewhere about working with indigenous peoples in the United States and in Canada, and how those groups can relate to one another in a more productive way that avoids some of the things that have come up here.
Nice question.
Yeah, thank you for that question. That's a really important issue, because really this dynamic between the Guarani and the Amazon Defense Front is something that is not uncommon. So, I mean, I think that NGOs, the key is really trying to engage with indigenous peoples at a grassroots level, and the community members, and to try to listen to them, to share information with them that you get from other sources, and to really try to listen and respect and support them rather than going in and just looking for, a mascot to take to a press conference or something like that. And it's really not easy. But I think that I've done some work in Alaska, and I know people in Canada as well. My sense is that the Native communities there really see the environmental NGOs as a very important ally in their struggles when they don't want oil and gas companies to come in and basically, take over and change their lands and their worlds. And so they see those alliances as important, but they also think that, the NGOs get all the money, have all the money, control all of the activities, just kind of want to use community members when they need someone to go to a meeting or for a demonstration. So I think it's really important to try to engage in a very open and dialogue with the people to try to help the indigenous organizations also get financial support, so that it's not just the environmental groups that are always controlling the budgets. That's a huge issue in Alaska. And to really, really know your intermediary and know who that intermediary is and whether they're really legitimate from the view of the grassroots people, or whether they are someone who's been more legitimized by external actors.
So it's 11:30 and the schedule says that we are supposed to take a break. And I know there are people who have both other questions and comments. As many of the speakers mentioned, virtually every issue that was raised in the individual presentations is going to be a subject of further discussion at the panels. And so I think if you hold your questions till the panels, we'll have more opportunity to pursue those. I'm going to take the prerogative of the moderator to make one general comment myself and then thank the speakers. Contrary to one of the things Mr. Boutros said, I think that all three of the presentations this morning demonstrated that one lesson to learn about complex transnational litigation is that it is never just about litigation. And experienced litigators, including all of the litigators who spoke this morning, are of course aware of that and would be remiss not to be aware of that in terms of the strategic decision-making and advice they give their clients. This litigation is perhaps the largest example, but not the only example, of a complicated, high-stakes, multi-party litigation that implicates important cultural issues, that involves governments and key political leaders, and indeed, whether or not it comes to pass in this case, frequently the only resolution of these kinds of cases is resolution that not only takes place in the court according to the proper rules of the court, but also involves important political figures, elected officials, and leaders of important communities, including the corporate community. So on that note, I want to thank all of our speakers.